In our June client update, we wish to inform you of the current status of the class action lawsuits and criminal investigations that are being brought against the various companies that we report on and whose claims we represent. The past few months have been characterised by intensive analysis, extensive research and numerous legal activities. Even though many proceedings take place behind the scenes and not every development is immediately publicly visible, we are continuously working to represent our clients' interests in the best possible way and to identify new approaches for enforcing existing claims. The coming weeks promise to be particularly interesting. For the months of July and August, we expect several developments that may be of considerable importance to many of our customers. Extensive updates are planned for the following topics: Lyoness, Lyconet and Myworld, Blocktrade SA, GS Partners, Karatbars, and Zeniq, Safir, XPRO and Homnifi. The background to this is ongoing legal proceedings, official measures, new research findings and pending decisions, which in our view deserve a more detailed assessment. Furthermore, our BE European Economic Interest Grouping has filed a formal complaint regarding official conduct in connection with the disciplinary proceedings concerning the senior public prosecutor at the Vienna Public Prosecutor's Office for Combating Economic Crimes and Corruption, the WKSTA. We will provide updates on this matter as soon as new developments become available. A particular focus of our work is currently on the further analysis of the payment structures surrounding Lyoness, Lyconet and Myworld. After more than 3 years of analysis, evaluation of numerous court decisions, insolvency reports and cash flow analysis, we now see the possibility of pursuing another important investigative approach in a targeted manner. The focus is on banks and financial institutions that have served the group of companies for many years and processed their payment transactions. The insolvency documents now available provide a significantly deeper insight into business relationships, banking connections and payment structures than was possible just a few years ago. At the same time, numerous public warnings, court rulings and official actions are now available, enabling a comprehensive reassessment of certain issues. Our goal is to create a reliable chronology and document it in a comprehensive manner. Which banks are involved, over what periods of time business relationships existed, which warning signals were already known at the respective times, and what measures the participating institutions have taken. We will initially focus on several Scandinavian banks, which according to current knowledge may have played a relevant role within the payment structures between 2012 and 2019. Based on these findings, we will decide on further steps. These include journalistic investigations, requests for information, official submissions, and if necessary, the examination of potential claims against the financial institutions involved. We currently assess the chances of gaining further insights as possible. In particular, the insolvency documents that have now become available open up new possibilities for analysing connections that were not accessible a few years ago. We regularly receive questions about the statute of limitations for potential claims. Based on our current assessment, there is no indication that the claims we are handling are time barred. The claims have been actively pursued for years. This includes, among other things, participation in criminal proceedings, measures in connection with insolvency proceedings and legal action, including the application for payment orders. Depending on the legal system, such measures have either a suspending or an interrupting effect on the statute of limitations. Furthermore, these are complex international matters involving numerous individuals, companies and jurisdictions. Analysing such structures requires extensive investigations and analysis, which can also be significant for the legal assessment of potential statutes of limitations. Therefore, there can be no talk of simply waiting. Rather, legal and practical measures have been continuously implemented over the years to secure claims and prepare for their enforcement. In recent months, we have been repeatedly asked whether our work is comparable to so-called recovery programs. The answer is clearly no. Neither BE Conflict Management Incorporated, BE European Economic Interest Grouping, nor BEUB FlexCap G offer or have ever offered a recovery program. Recovery programs typically aim to offset losses through new investments, token memberships, or other participation models. Our approach is fundamentally different. We operate on the basis of an assignment of receivables model. Existing claims are bundled, documented, and pursued through the appropriate legal channels. The goal is the enforcement of existing claims, not the creation of new investments or participation in another business model. We consider this distinction important because both models have completely different goals, legal foundations, and procedures. You can find more information on this topic in our article, Anyone Who Immediately Labels Every Allocation as Fraud Simply Hasn't Understood the System of Conflict Management. The past few years have shown that international issues are becoming increasingly complex. Responsible individuals, asset companies, and payment structures are now often spread across multiple continents. At the same time, victims are often located in different countries and legal systems. We are therefore convinced that our own structures must also continuously evolve in order to create the best possible conditions for our customers to enforce their claims. For this reason, we are currently working on the establishment of a European Cooperative Society for Legal Interests, or known as an SCE. The new structure is intended to help to more effectively pool the interests of those affected from Europe, North America, Australia, New Zealand, Africa, and other regions in the future, and to represent them vis-à-vis authorities, law firms, insolvency administrators, supervisory authorities, and other institutions. Our goal is to further expand international cooperation, strengthen transparency, and in the long term create an even more effective platform for cross-border enforcement of common legal interests. The BE European Cooperative Society for Legal Interests, at a glance, consists of the following: member organisation, advocacy, international pooling of common concerns, the BE European Economic Interest Grouping, which comprises of international coordination, process management, and the cooperation with law firms. And then BE Conflict Management Incorporated consists of international activities outside of Europe. BEUB FlexCap G covers the administration and organisational infrastructure. You can find more information on this topic at our article, Next Step, From Lobby Group to European Institution, BECM expands its structure with a Cooperative Society for Legal Interests, BE Conflict Management. I'll provide links for these articles at the bottom of this video. We thank you for your trust and will of course continue to keep you informed about all significant developments moving forward.